Hello again, Attorney Nydia Menendez here. In the prior video about wills, I explained what a will was and why a will by itself will probably not serve you well. In this video, I will be talking about trusts. Now here are some of the most common myths I hear about trust. A trust is for wealthy people. Or, I don't have assets, so why do I need a trust? Or, I already have a will, isn't that enough? Or, it's too expensive. And if this was a true or false quiz, the response to each of those myths would be a big fat false. So what is a trust? Here we will be talking about a revocable living trust, which is the basic trust commonly used in estate planning. A trust is a legal agreement where you, as grantor, the creator of the trust, transfer your assets to the trust. You can think of the trust as if the trust is a company, and you give specific instructions to the trustee. The trustee is the person who manages the assets in the trust for the benefit of the beneficiary. While you are alive and have capacity, you can be all three of these parties. You can be the grantor, the trustee, and the beneficiary. This means that you are not releasing any control or benefit from the assets in the trust. Essentially, nothing really changes. So then why have a trust? The main reason to have a trust is because it acts as a standby device, a just-in-case tool so that you can have a plan, always be in control, and protect what really matters to you. For example, if something were to happen to you because you have appointed a successor trustee, there will immediately be someone chosen by you to manage your assets. Notice that because the assets have been transferred to the trust, there is a successor trustee to immediately manage the assets in the trust without any court involvement. So let's say you become incapacitated during your lifetime, which, by the way, statistics tell us 70% of persons 65 and older will experience some form of incapacity. The successor trustee would manage the assets in the trust for your benefit. Without a trust, you would need to go to court for guardianship, and the court would supervise the management of your assets, even for your own benefit. A trust is also very useful when the grantor passes away. Once again, because the assets are already in the trust, a successor trustee has been appointed, then there is no need to go through the process of probate to transfer the assets to the beneficiaries. And the greatest benefit is that the distribution to the beneficiaries could also be in trust instead of outright. For example, if your beneficiaries are minors or have creditor issues or are contemplating divorce or receive government benefits, then outright distributions to them is likely not desirable. These distributions will be best preserved if they are done into a trust with specific terms matching the unique needs and circumstances of each of your beneficiaries. So you can see a trust has built-in succession plan, which includes a successor trustee to essentially substitute you, which is why when your assets are transferred to the trust, your estate does not need to go through the judicial process of guardianship or probate, and you can control distributions to protect your beneficiaries. If your goal is to put your affairs in order, a trust should be a key part of your estate plan. Visit our website to register for a webinar where you can learn more about estate planning. If you like this video, please like and share. If you want to see more videos about estate planning, subscribe and ring the bell to be notified when we release the next video. Thank you for watching and see you soon.